Welcome everyone to our intellectual property protection webinar featuring attorney Cheryl Black. We are so excited to have all of you attending today. I just wanted to make sure that you guys were muted and that you guys are ready for lots of information that can help you with understanding the value of intangible assets. If you are a small business owner and learning about how you're able to protect intellectual property that you may be able to use in order for you to achieve competitive advantage and profitability. I'm very excited to welcome attorney Cheryl Black, who has many years of intellectual property protection experience, and she is going to share her wisdom with us today. So thank you, attorney Black. We're very grateful to have you, and I am going to turn it over to you.
Thank you, Dr. Perry Rivers. I am excited to be here and to share what information I have with you as entrepreneurs and small businesses owners, and the importance that intellectual property plays into what you're doing and what you're trying to do. I'm excited to partner with VSU's Minority Business Launch Center to hold this workshop. From the onset, I just want to say I am a licensed attorney, but this is not legal advice that I'm giving you. This is educational, for educational purposes. This is informational. And so I hope that you're able to glean as much as you can. But if you have a particular matter that you're looking for legal advice on, then I have to recommend that you seek the counsel of a private attorney that can understand your facts and apply the law to your facts and provide you with the proper legal counsel. So having said that, what I'd like to do is get a sense of who we have with us today. And so we have a quick poll just to start out, just to ask you in terms of your familiarity with intellectual property and kind of get a sense of what you're looking to get out of today's workshop. So if we can pull that poll up, that first survey. And do I need to stop sharing my screen for that to happen, or can you see the poll? Dr. Perry Rivers, can the poll be seen?
We don't see the poll yet.
You do not see the
poll? We're pulling the poll up right now. So it should be starting in just the next couple of seconds.
Do I need to stop sharing my screen for it to work?
Yes, if you could, that would be great. Thank you.
Okay.
I am able to see the poll survey.
Okay, great. So we'll take a few minutes just to answer this one question, just in terms of where you are. A single choice would be great. I don't know if I have intellectual property is the first one. I think I have intellectual property, but I don't know what kind. I know I have intellectual property, but I don't know how to protect it. Or I may have an issue related to intellectual property and I need to know where to go for more information. So those are the questions. And we're just doing that one. We're not doing the objective one. It looks like some people are answering the next one. We should just have.
Right, you should just have one, but since we see them all displayed here, just answer the first question.
Okay. So it looks like we've got complete, we've got 100%, so we can stop the poll. It looks like majority of you don't know if you have intellectual property, and then about a quarter of you think you have intellectual property, but you don't know what kind. So I really appreciate that feedback, and we'll stop the poll now, and we'll move back into the slide presentation, and we'll get started, because the point of this workshop is to address those concerns and those questions. So what we'll be looking at as my slide starts. There we go. So the objectives that we have for today are to identify and define the 4 types of intellectual property, which is going to answer that initial comment that you had in the poll. Understand where intellectual property fits in the law, and then we'll identify some ways to protect intellectual property. And since most of you are not concerned about an infringement issue or legal issue, I'm going to give you a broad brush of what that is. And then we're going to leave you with resources that you can use to learn more and to move forward in trying to protect your intellectual property. Now, intellectual property is a very long phrase. So sometimes I use IP, which stands for intellectual property, in exchange for intellectual property. I just want to mention that so that you're understanding. I know sometimes I use terminology and I forget who I'm talking to, so I wanted to bring that to your attention. And so I know that I am not teaching to a class full of law students or lawyers, although some of you may be, but I recognize that. And what I've learned is that one of the things that is important about teaching the law is using business case studies. And so what I've selected for today, and I hope that you'll appreciate it, is I'm in light of the Crown Act, which stands for Create a Respectful and Open World for Natural Hair. The Crown Act was first enacted in California in 2019, and since then, 11 other states have adopted this act, with Virginia adopting it in March of 2020. And being the fourth state to do so. It bans discrimination based on hairstyles. Isn't that cool? And it's in Congress, US Congress right now. But the issue with that is that it's passed the House of Representatives, it's sitting in Senate, but states are enacting this, and Virginia is one of them. And in Virginia's law, they amended the definition of discrimination because of race or on the basis of race to include discrimination because of or on the basis of traits historically associated with race, including hair texture, hair type, and protective hairstyles such as braids, locks, and twists. So I think that's historical. I think it's important, especially because we're dealing with minority-owned businesses. And I couldn't think of two better case scenarios than Madam C.J. Walker, who invented hair care products to help because she had a problem with her hair loss. And this is back in the early 1900s. And so she was struggling with hair problems and hair issues and needed a product to spur her hair growth as well as to treat her scalp. And so she is one of the business cases that we will look at today. And then fast forward to 2021, we have Naturalicious, which is owned by Gwen Jameer, who is the first Black inventor to own a patent on natural hair care products. And so I know it says something that we're talking a span of a century where we have inventors of hair care products, and we have our first Black inventor who owns a patent on natural hair care products. But that's a discussion for another time. We will focus on them as the case studies as we introduce intellectual property. And so with that, we're going to start with our first objective, which is what is intellectual property? And it's broken down into 4 types: trademarks, copyright, patent, and trade secret. So let's look at the first one. And this part you can be interactive with. So when I show you this slide, I'm gonna identify certain things, and then you're gonna tell me what products and services come to mind. So you can unmute for this, or you can talk in the chat box. But when I show this one, which is the Golden Arch and McDonald's, what comes to mind for you? Let me see if I have anybody in the chat or anybody unmuted, any products or services that come to mind. Fast food, yes. Convenience, yes. Big Macs, French fries, right. And then we have, McDowell's, that is funny. So we have that. And then what about this symbol? What comes to mind? What products or services come to mind when you see this symbol? Cars, exactly. Automobiles, Toyota. And then what about this one? This one might be a little bit trickier. Any guesses?
Like
fragrance, exactly, perfume. And then we've got IKEA. What comes to mind for that? Furniture, exactly. And then what about this one?
Agriculture.
Agriculture. And what kind of product or service? John Deere, yes. Tractor trailers. And then this one you have to actually listen to. Anybody want to take a guess on that one?
Communication.
NBC, yes, broadcasting services. And so what you'll see with these is that just looking at that symbol, you recognize a product or service that's sold under that symbol. So those are what trademarks are. And if you look at these, you'll see you've got logos like the Toyota. It doesn't even say Toyota, but you know that's the Toyota brand. IKEA, which is a name. Yep, and yep. So I'm gonna talk now. So I'll have another time that you'll chime in. But IKEA, you'll see that. The product, the fragrance one, this bottle.
And it's gonna be a lot of changes. They're already implemented. Like I said, this is.
I'd like to just encourage everyone to make sure that their microphones are muted while Attorney Black is communicating with us. Attorney Black, do you mind unmuting your microphone? Because I've made you a co-host. There you go.
Okay, so you can hear me now?
Yes.
Yeah, so what I was saying about the symbols that you see here, there's different types of symbols. So you've got the logo, the John Deere, actually the green and yellow are the colors, and they have a registration on the colors for tractor trailers, and then sound. And so what you'll see here, let's see if my slide will advance. Yes, so what you'll see here is there are different ways to use trademarks. So it could be a word, it could be the name, Madam C.J. Walker, for example. It can be designs like the Toyota logo. It could be color, the John Deere, the sound, NBC. The key thing to remember about trademarks is they are source indicators. You know what source you're getting. Someone in the chat said they think of reliability when they think of one of those trademarks. So it's a goodwill associated, the reputation of that brand, if you will. So it's a source indicator of what you can expect when you see that brand on that product or service. So it's used to identify products and services, and it's a product and service differentiator because it distinguishes from another one. So we've got Madam C.J. Walker, wonderful hair grower, and she's got hair products, and we've got Naturalicious. They're both hair care products, but they're under different brands, and so you expect different things from those brands. And so that's what a trademark is. So now let's look at copyright. And so when we look at copyright, we might think of books and music, the lyrics and the score, building designs, that's the African American History Museum there, paintings, sound recordings. They used to be on LPs, the record labels. Now they're on, and then there were CDs and discs. And so anyway, but sound recordings of the recorded music, and then even statues, right? So these are the different types of works, and there are even more. So what is a copyrightable work? The key about copyright works or copyrightable works are that they are original works of authorship, and there has to be some creative expression. It can't just be an authorship. There has to be creative expression, and it's minimal, but it still has to meet a certain threshold under the act. And then it has to be in fixed, tangible form. So if I recite a poem, but I have no written document of that poem, it's not copyright protectable. But the minute I write it down on a piece of paper or I type it onto the computer, it's in tangible form, and then it's copyrightable. And then the other thing about copyrights is the creative expression. So recipes or names and titles. The title of a book is not copyrightable, but the manuscript, the book itself, the literary work is protectable by copyright. But there are different types of categories: music and drama and motion pictures, architectural works, literary works. So those are things that are copyrightable. And I say copyrightable because you have creative works that may not be, or you may think that they're creative works. Ideas and concepts are not copyright material. And then we have patents. So we have inventions. What type of inventions? So I put on here the smartphone and the self-driving car, because those are things that are popping up now and that we use a lot, and they're inventions, and there are patents associated with those technologies on these actual useful instruments, right? So a telephone is a useful device, and there's features of the telephone that are new and novel. When I was growing up, the telephone was a hardwired device with a hand device and then a rotary dial. And now we have one device in our hands and we tap it and we talk. And so the different developments over time of a telephone are new and novel features that have created that invention. I thought you would get a kick out of this invention, so you have to listen
Michael
up.
Jackson was a man of many talents, including one we bet you didn't know about. A shoe Jackson designed and, along with two partners, patented in 1993. It's described as a method and means for creating anti-gravity illusion. It works because of a special cutout in the shoe's heel. It hitches onto rods that, when needed, come up through the stage floor, all but nailing down the dancers.
Now you know his secret. And then I mentioned the other inventor, Gwen Jameer. And so this is just a little snippet about her becoming the first Black to own a patent in natural hair.
And new on Local 4, Gwen Jameer is the first African-American woman to hold a patent for a natural hair care product. She's a Detroiter, and she did it while creating her own company and becoming a mother. And did I mention she was out of work at the time?
I was going through a really, really tough time in my life at the time. I had just gotten laid off from my job, and I was also in the midst of a really grueling divorce. And I literally had no money. I had a 2-year-old at the time, and it was tough.
The idea came when she was expecting and was frustrated about how much time hair care took.
I was pregnant with my son, and I needed something that was going to save me time and money. I was spending anywhere from 2 to 4 hours on my hair.
Necessity being the mother of invention, Gwen needed to educate herself in patent law to create her invention.
I spent a lot of time at the library making really, really good friends with the librarians in my area, and I learned patent law. I taught myself a lot.
A patented product called Naturalicious was born.
It is a cleanser, a conditioner, a deep conditioner, a leave-in conditioner, and a detangler, all in one product.
Part of Gwen's patented formula includes ingredients from Morocco. Like a professional scientist, she experimented.
I purchased some, mixed it with the other oils I was already familiar with, and lo and behold, the gates of heaven opened when I used it on my hair. It was amazing.
Now her invention is available in local stores. Along the way, her 5-year-old son has gotten involved.
My son is the chief candy curator. So in every order of Naturalicious products, if you order online, you actually get a little bag of candy.
And she has support from family and a new relationship.
To make sure that she's hitting her potential, I'm going to provide any support I can. I don't ever want her to hit a roadblock that she's not able to overcome.
Waiting is not a wealth strategy. I say just go out, just jump and do it, because what's the worst that's going to happen? If you are not successful, you're going to be in the same place that you were when you started. You haven't lost anything, so why not try?
Isn't she amazing? Her boyfriend's amazing.
So that is, so as we look at inventions, and that's the kettle I put up there too. So
Michael Jackson was a man of many.
As we look at inventions, we'll see there's different types of inventions that can be patentable. So useful process and methods like computer programs, machines, articles of manufacture. Who knew that you could patent a feature of a shoe? Michael Jackson did. Composition matter of new arrangements, food products, formulas for hair care, and even design features of functional objects. So I showed you the smartphone, and I don't know if you know, it's not just the useful functionalities of the smartphone, but also the design and the layout of the smartphone. And some years ago, there was a big litigation dispute with Apple versus Samsung. Millions of dollars, tons of litigation, years of litigation. And one of the things that emerged and bubbled up from that is that design patents actually have a lot of value, because that was one of the big battles, and damages were awarded, remedies and recovery based on the design patents. So that's a valuable part of intellectual property. Patents can be useful features or design features of useful inventions. It has to be new and novel. So you can have an invention, but it doesn't necessarily mean you can get a patent. So that's an element that's really critical for patent protection. And then there are trade secrets. So what types of things can you keep secret? Well, inventions that are not patented, you could keep as a trade secret. Ingredients of a recipe, you could keep as a trade secret. Business strategies, product launch dates, anything that gives you a competitive edge over your, competition, market share, that's proprietary and that's kept non-public. It has to be kept secret. It has to be original, and then you could potentially protect that trade secret. So those are the 4 types of intellectual property. And we want to make sure that you understand that as we move into the next parts of this workshop. So we're going to do the poll on the types of intellectual property. So I'm going to stop sharing so that the poll can show. So do we have the poll up? Can we start that poll? On the object one. So the first one is, where is the poll? Yeah, so it is used to identify products and or services. So 50% said trademark and 50% said patent. And so remember, we talked about trademarks being a product and service differentiator. So the brand or trademark that you use is what differentiates it from other competitors. So that would be that it would be a trademark. And then the next question is, an inventor can receive these rights for the new or novel features of their, I'm not sure what's happening with the polling.
So I apologize, Attorney Black. What we need to do is to relaunch the poll, because we actually didn't get enough people to participate and respond. And so what we need to do is ask everyone to answer. Is it question 2 or question 3 that you would like them to answer for you to get feedback?
So now we're on question 3, because okay. I just responded to 2. So 3 is, an inventor can receive these rights for their new or novel features of a useful invention.
So did you want everyone to answer this question now?
Yes.
Okay. So everyone, please answer question 3. You should have access to it.
Yes, and they can answer question 4 as well, which is, it affords authors and artists exclusive rights to their music, literature, art, and other creative works. 100% copyright, excellent. 100% on patents for the inventions, excellent. And so, well, we've got 33%, but, oh, it's going down. An inventor can receive rights for the new and novel features of a useful invention, that is patents. So I'm just going to move ahead because we have a limited time. If it affords authors and artists exclusive rights to their music, literature, arts, and other creative works, we have copyright, which is the correct answer. And then the last one we'll take in this survey is, it is a business's confidential information. And yes, those can be confidential. Trademark can be confidential. Patent can be confidential if it's not disclosed to the public. But what has to maintain confidentiality to be an intellectual property right are trade secrets, right? So we're going to end that poll. And I'm going to go back to the slide so that we can move on to the next thing, which is the intellectual property law primer. So we've talked about the types of intellectual property: trademark, copyright, patent, and trade secrets. So where does the law fit in that? We're going to go through an overview of what intellectual property IP law is, and then an overview of the laws that relate to each of those types of intellectual property. And so when we think of property, we usually think of real property, like real estate property, property we can see: a house, land, buildings. These are tangible properties, and we know that there are rights associated with them. So I've listed some of the rights in the slide. You can buy and sell it. You can lease it. Maybe you're leasing an apartment. You can be the sole owner, or you can be a shared partner. You can have the deed of a house could be in your name or the name of you and someone else, right? A significant other. You can use it as collateral. You can take your land, you can take your property, you can invest against it. You can get investments and use it as collateral to pay off that loan, right? And then you can leave it for others. So we're talking generational wealth. We're talking passive income. Madam C.J. Walker's products still exist today. She left it for her heirs, and it still exists today. So that's generational wealth. The other amazing thing that she did was she did not just use that intellectual property for herself and that business for herself, but she had people that worked, agents. They became agent owners. So this multi-level marketing, where they could buy the product from her wholesale, and then they could sell it retail, and then they can make their own money and generate their own revenue and have their own piece of the pie. And so there's a lot that we can do with when we have property rights. Gwen Jameer she lost her job. She had $32 in the bank when she came up with this invention. She went through the process to get a patent rights. She's a millionaire now, right? So there's a lot of economic empowerment to owning that real estate in intellectual rights, intellectual property rights. So how do we own it? How do we protect it? So the US Constitution provides for the protection or the monopoly, limited monopoly for inventors and for artists in their writings and in their inventions. It's actually in the Constitution. And with trademarks and trade secrets, Congress has the power to regulate commerce. So trading with a trade name, trademark, gives them the right to enact laws to protect the flow of goods and services under a trademark. And then trade secrets, again, we're talking about commerce. And so there are federal laws that protect each of these type of intellectual properties. So there's the Patent Act, the US Copyright Act, the Trademark Act, and most recently, the Defend Trade Secrets Act. And all of those acts provide for the protections of owners of those rights and remedies that the rights owners can take if somebody violates those federal rights. So there's a lot at stake in protecting your intellectual property, because it gives you the power and the right to do the things that we just talked about, but it also gives you the power and the right to enforce it if someone violates those rights. There are also common law and state laws related to trademarks and trade secrets. And then there are opportunities to get international protections. We're living in a global economy. A lot of people have their products made in other countries and imported into the US. So you want to have protection in other countries as well. And we're selling across seas on the internet, right? And so through international treaties, the US has partnered with other countries to allow for the protection and the extension of protections in other countries under their foreign laws. So there are a lot of protections afforded to intellectual property. That's really wonderful to know, I think, as a business owner, because you might not have real property, but if you've got a business, you probably have some intellectual property. And now you're learning how to protect it. And so what are some of the ways that we can protect this intellectual property? Well, when we look at trade secrets, remember, trade secrets are protected as long as the information remains confidential. And how do we keep that confidential? Contracts, 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 contracts. There's what's called a non-disclosure agreement. Maybe you've heard of NDA or confidentiality agreement. What that is it's a contract between you, the party who has that secret information, and another person who is going to be receiving that information. And what that agreement means is that you explain, I'm sharing this information, but you can't use this information to compete against me. You can't use this information to go out and make that product on your own. You can't steal this information from me. You can only use it for my benefit and to help me. So if you have a vendor that needs to make your product and they need the ingredients or they need the strategies or the formulas or the processes, you can sign under an NDA to protect the interest that you have in that trade secret right. And then there's recourse that you write in the contract if they violate it, but there's also federal rights, which you just learned about. But protecting trade secrets means that you need to have contracts. Even with investors, you may want to have a contract with an investor. Secure data, I put this in terms of internal and transmission because the trade secret is protected as long as it's kept secret. And before we had printed paper and you marked it confidential and you shared it, but now we transmit everything electronically and digitally. Well, you want to make sure that the information that you have electronically is secure and safe. And when you transmit it, that it's secure and safe. So there's measures that you might want to take when you are transporting that information and sharing the information to make sure it stays secure. Because if there is a breach and that information becomes public, it's no longer a trade secret. Patent protection. So inventions can be protected under patent law. The US Patent and Trademark Office is the only place that you can get patent protection in the United States. They have to issue the patent for that invention. And patent rights give you the exclusive right to keep anybody else from making your invention, using that invention, selling it, offering it for sale, or importing it in, right? And so that patent lasts for 20 years if it's based on the useful features, 14 years if it's for the design of the useful invention. And the patent process can be complicated, but Gwen Jameer just shared with us, she did it herself. So it is doable, but it's a lot of work and it's very complicated. And here are some steps that you should keep in mind if you want to pursue it yourself. And I will also share some information at the end about resources to use. And that reminds me, there was a question in the chat. I will take those questions towards the end of the presentation. But you need to be able to describe the invention so that somebody else knows how to make it, even though they can't make it without your permission. But how do we know that this is an invention and that it's useful and it has features if you can't describe it in writing and specifications? And then the drawings, and then the field of technology of what type of invention is this? What category? Remember, I showed you compositions of matter and articles of manufacture. So you want to understand the field of technology, what's already out there, and how yours is different, how yours is new or novel to what already exists. And then you want to identify the type of patent. There's a provisional and a non-provisional, which we can talk about a little bit later. You file the application, you pay the fee, and then they examine it. And if they have questions, they'll ask you, they'll send you notices and office actions, and you have to respond. So you might want to hire an attorney if you can afford one. And there are certain things that an attorney or a patent agent can help you with. The searches of the field of technology, whether there's something already out there, whether there's something out there that's patented, and that means that you can't do this work. The filing requirements on the disclosure, understanding ownership and patentability, and then the patent process itself when you file it with the patent office. And if there is a matter of infringement or violation of rights, those are times that you might want to seek the counsel of a patent attorney. And I'll talk a little bit more about that towards the end, but I just want you to know the way to protect an invention with a patent is only through the U.S. Patent and Trademark Office. You can extend those rights and seek protection in other countries, but you start with the U.S. Patent Office. And then there's the federal trademark registration. We talked about the Federal Trademark Act. And so the federal trademark registration gives the owner exclusive right to use that mark, the trademark, on the products and services that are identified. So you can't just reserve a mark and say, oh, I like this mark, this is mine. No, it has to be associated with products and services. And that registration lasts 10 years and can be renewed every 10 years. And there's a process that you go through to get a trademark registration, which includes seeing if anybody else has that mark that you're thinking about, whether it already exists. And if it does it exist for the same products or services? So you want to think about that. What the mark is, we talked about all the different types of ways you can have a mark, what the products and services are. And then there's different bases for filing. You file the application and then you go through the examination. One of the key things to keep in mind about trademark protection is you have to use it. It has to be used. And so that's why it's kind of hard to keep it a trade secret, because in order to have the rights, there has to be use. And so common law means you can be using it and trading under this trademark without getting a trademark registration. And so that's common law rights, there's state law rights, and then there's federal rights. So even if you file an application with the trademark office before you use it, you still have to have use. And so I'm going to show you the patent that was issued to Gwen Jameer at the end of the presentation. And I will also show you her trademark registration certificate for Naturalicious. But I wanted to make sure you understand that this is the process in going through this. And I will have resources for you at the end to help you figure out if you want to pursue trying to file for protection yourself and the steps that you would take. This is an overview, but I will go through a little bit more towards the end. And then there's copyright protection. So copyright protection gives the owner exclusive right to all of these things, to make copies, to distribute, to make derivative works. What are derivative works? Well, think about J.K. Rowling and the Harry Potter book, and then she wrote several books, and then she had movies. And so the derivative works of that, public display, public performance, you write a play, it's performed in public, those are your rights. And it lasts life of the author plus 70 years. That doesn't sound like a limited time, like the Constitution said. Well, through amendments, they have expanded it. So it doesn't really seem like it's a limited time, but this is how long a copyright lasts, or 95 years if you commission someone to do the work for you and then you own the rights. And again, that protection is automatic when it's put in tangible form. But in order to enforce your rights against anyone, so someone takes your copyright or copies it and starts distributing it without your permission, you have to have a registration from the Copyright Office. So you have to register your work with the Copyright Office. I have also on here copyright notice, you know, the C in the circle with the year and author, like I have that down here on my presentation. That gives notice to people that this is your copyright. Like, I own this creative work. And you do own it, but you can't enforce it again unless it's registered with the Copyright Office, but it is yours, and it gives people notice so they can't claim innocent infringement if there is an issue. So it's helpful to put that information down there. And so that's copyright protection. And so I think we are going to look at that a little bit more with the polling. So let me, Am I still here with everyone?
Yes.
Did you all see?
Oh, yeah, we saw you.
Okay, great. I got a little nervous because I was like, it's not showing up on my shared screen here. So we'll do the poll for survey number 3, which deals with how do you protect intellectual property? Do you know what it is? If we can set up the poll, but you can see it visibly. I won't worry so much if you don't get the answer in before I get to the question, because really what's important is that you understand it and that we have enough time to cover the material. So let's see what we have for this. So this is the last poll, and we need to go to the next poll. I don't see. There we go. Thank you. So there's 6 questions in this one. The first one is intellectual property owners are afforded some of the same rights as real property owners. Is that true or false? Anybody want to take a guess at that with the polling? Oh, did the poll answers not come up until it's finished? Is that what that is?
It actually gives a running tab. So everyone go and make sure that you take the polling questions for objectives 2 and 3.
Yeah. So the first one is it afforded the same rights as real property owners? And that answer is true. We talked about that you can license your intellectual property, you can sell it, you can leave it for your heirs, you can have generational wealth with intellectual property. And then the second one is intellectual property can be protected in the US and in foreign countries. And the answer is true. You can extend those rights and seek protection in other countries. Then which intellectual properties can only be granted by the US Patent and Trademark Office? Yes, patents are the only one that can be protected that way. So you can have an invention, but you might not be able to protect it under patents. But all the other ones, you can have federal protection, but you can have protection by using it. And then which intellectual property is protected by non-disclosure? We're going to say trade secrets. It has to be kept secret, and it has to be proprietary. And then the copyright protection is automatic, but it must be protected it must be registered with the Copyright Office for you to go into court and sue somebody for infringing on your copyright rights. And then which intellectual property requires ongoing use to maintain its rights? Trademarks requires that. You have to be using it. Copyright, you can have it and never publish it. An invention you can have and never make it. You can exclude others from making it. These are constitutional protections, whereas trademarks, because it's based on commerce, it has to be in use. And that's how you maintain your rights to that. So we'll close that up, and then we will make sure that my screen is set up for the PowerPoint, and we will go back to that slide. So I just want to talk a little bit about infringement. What is infringement? We talked about protecting your rights. What about the violation of rights? And this is important to know as a business owner, that you don't want someone else infringing on your rights, but you also want to make sure that you're not infringing on anyone else's. And so I want to go back to Madam C.J. Walker, because when she was looking for solutions for her hair problems, she ran into a woman called Annie Turnbow. And Annie Turnbow had a hair product called Wonderful Hair Grower, a Great Wonderful Hair Grower. And it worked for Madam C.J. Walker. And so she started using the product, and then she started working for Annie Turnbow, and she started selling the product. And then eventually she came up with her own hair care product and started her own business. Well, Annie Turnbow was like, wait a minute, you're using my product to sell it. You're infringing on my rights. And Madam C.J. Walker was like, no, I'm not. Because let's look at this. It was a formula, right? It wasn't protected under patents, so was it a trade secret? Well, if Annie did not have Madam CJ sign an NDA to say, you can't use this for your own purposes, you can only use it for mine, and Madam CJ Walker was aware of the formula and knew how to make it, there was no trade secret there. And if Annie Turnbull didn't have a patent for it, then she couldn't say you violated my invention of my formula. And so there's no infringement there. Now, if someone came along and did that with Gwen Jameer's Naturalicious, she could have a case against them because she has a patent for her formulated hair care. Well, Madam C.J. Walker came up with Madam C.J. Walker's Wonderful Hair Grower. And Annie Turnbull's was Great Wonderful Hair Grower. And they're both sold on hair care products. So the products are the same. Are the trademarks the same? Or are they so similar that consumers would be confused that maybe they came from the same source? When we think about those terms, we know Madam C.J. Walker's source indicator comes from Madam C.J. Walker. Great Wonderful Hair Grower, does that sound distinguishable from Madam C.J. Walker's? And so these are kind of some of the questions you would ask when you're looking at what you have and what someone else has, and whether the terms are just descriptive, like it's a hair grower. Wonderful is like just a laudatory term, that it's a wonderful hair grower, but does it really tell you what the source is, right? And so those are some things that you think about when you're thinking about your proposed mark and what someone else has and what they're selling. A reasonable person, would they be confused? Would you think that they came from the same source? And then when we deal with copyrights, what we look at is copyright. A lot of times things are on the internet. And so I might have a photograph or an image, and we see this all the time. Everybody's taking photos and putting them up. And so, a photographer has rights in their photograph. So if someone else takes that photograph and uses that photograph without their permission, distributes it or copies it or displays it, is that a violation of one of the exclusive rights of the copyright owner? Because they own that right. And so you want to think about those things when you think about taking things off of the internet. Even if it's an image of yourself, if the photographer took it and they own that copyright, then you could have an issue. So what I do with my slides is I usually use like Adobe stock images or Unsplash, where they're free images that I can download and I can add to my presentations, and the websites will tell you what type of license you have and whether you have to give attribution to the creator or not. But just because it's on the internet doesn't mean it's free and doesn't mean you can use it. And if you are caught, then you may have an issue with infringement. So that's something to keep in mind. And this is not exhaustive or comprehensive. This is just a broad brush stroke so that you're aware that these issues happen, and you're aware for yourself in when you put your things out there, but you're also aware if someone else encroaches upon your rights. So I want to leave you with discovering more, right? So I've given you a lot of information, but where do you go for more? Say now you figured out, I do have a trademark, or I do have copyright, or I do have, an invention that I think is new or novel. Where do I go for more? So let's start with trademarks. And I use the term trademark, and you might have heard me say brand or mark. They're all kind of synonymously used. But when we look at trademarks, the way to find out if your proposed mark is available is you can conduct a search. And remember I said that there are common law rights, there are state rights, there are federal rights. There are databases that you can look at But in a common law search, which means it's just use in commerce, in the flow of the marketplace, you can use a search engine like Google and see if anybody else is using that proposed mark with their products and services. But states, they have their own trademark databases. You can look at that. And then the USPTO, which is the US Patent and Trademark Office, they have a database of every application and every registration that has been filed with the US Patent and Trademark Office. And those applications serve as constructive notice to the public, meaning even if you don't know, now you know. So if you go on there, you can find out if someone else is using that trademark and then what products and services they're identifying. Because it may be that it's a similar mark, but it's completely unrelated goods, and maybe there's not an issue. Again, that would be for you to talk with an attorney about. And then there are commercial search companies that you can hire and say, I don't know about this. I don't know if I want to deal with this. You can hire someone to do that search for you and give you the results to figure out if your mark you can move forward with or if there's any issues. If you just use your mark and you don't want to go forward with filing an application for federal registration and you're just using it in common law and you're like, I'm not going to worry about that. Make sure you keep your proofs of sales and services, right? Because the evidence that it's yours, if someone else comes after you or that you go after someone else, the evidence you have to provide without a federal registration are your proofs of sales, your dates of use, your geographic scope. And then I recommend using the TM symbol to let people know that you're claiming that as your trademark. For the federal trademark application process, the USPTO website, I used to work for the US Patent and Trademark Office, by the way. It is full of helpful, useful information for the general public so that you can learn everything you want to learn about trademarks. There's a trademark page and it has basics of information. It has information about searching. It has information about filing the applications. There's a place on there that you can file it directly. And that R in the circle symbol is only awarded and only used by those who receive a certificate of registration from the US Patent and Trademark Office. And then there's copyright. Like I said, it's automatic on protection once it's in tangible form, but you can also register with the Copyright Office. They have an electronic copyright system that you can register. And they also have circulars. Circulars are just little fact sheets about different types of copyright works and how do you register and what do you do, and it's very useful to the general public. And so I would recommend taking a look if you're thinking, well, why aren't recipes copyrightable? They have a circular for that. You know, computer programs, they have a circular for that. And so there's a lot of good information on that website. And then trade secrets, again, contract. Before you let the baby out, before you let that secret out, make sure you understand, you know, NDAs and having those signed before you share with people who could potentially take it and trade. And I have to share with you, I've had clients before that shared their ideas with potential business partners, and the business partners ran off with the ideas. They didn't have any other rights because they didn't have a patent, they didn't have anything, and there's no recourse there. So you really want to make sure you protect that early and fast, and especially before you get a patent. If you have an invention, you want to make sure you have non-disclosures. And as far as data security and protection, the Federal Trade Commission has guides for business owners on being secure and safe in how you handle matters and in cybersecurity. So you might want to check their website. As far as NDAs, business attorneys and IP attorneys could be a useful resource for you. And then with patent information, resources about that. I'm trying to rush through so I can finish all the material and then I can handle questions. But with patent information, there are searches. I talked about the freedom to operate, that you're not infringing on anybody else's patent, and then patentability, that you have something that could potentially be patentable. There are search engines like Google that you can use. There are more user-friendly than the USPTO's. database because it's very technical and you have to understand the classifications and the technology when you do the searches on the patent database. You can also hire commercial search companies who that's their business, is searching those databases and giving you the results to see, you know, what's available. And even with them, you may want to have them sign an NDA as you share your invention for them to go ahead and do the research for you. And then there's also, again, US Patent and Trademark Office. I highly recommend using their website. They have a patent page and they have a lot of useful information for independent inventors, which is going to be on my next slide, basic information about patents. And again, Gwen Jameer is one of our examples. She didn't have the resources to hire an attorney and she figured it out for herself. It took her 6 months. She trial and error, a lot of things. It can be done. And I have a recommendation for a book called Patent It Yourself. It's a NOLO publication. I've even used that. I've used it to look through some of the material, and I think it's a wealth of information for non-attorneys and even attorneys to understand the patent application because it is a complex system. And so there are also times that you might want legal representation. We're talking intellectual property. I've covered it. I've tried to cover it in an hour. I've only just scratched the surface of the information that's available. And if you have the time, you can use the resources that I recommended. But if you have the resources and you want to make that investment with an attorney, there are some places that you can go. First up on, and this is not priority wise, but what I have as the first bullet is Jordan IP Law. That is a minority owned intellectual property law firm. All they do is intellectual property law. And I've actually hired them when I was in-house counsel. When I was general counsel for a company, we were doing a lot of patent work. I hired Jordan IP to help us to get those filings done. I also worked for the firm because I really believed in what they're doing and how they are very good at what they do. So if you're looking for a minority owned law firm, that's a go-to firm for me. And I do refer them a lot of work because I believe in what they do and they do good work. There are other legal resources, assistance and resources that I recommend. Patent pro bono program. So the USPTO has a whole page devoted to legal assistance and resources for entrepreneurs, independent inventors. Patent pro bono program is, pro bono is for free or for reduced rates, right? So that might ring the bell for some of you. And so you can look at the resources that are there. Law schools have IP clinics, which are clinics that are run by the law school, and the law students help with the filings of matters before the Patent and Trademark Office. And so that's done at a reduced or no cost to the client, but you have to meet certain eligibility. I know the University of Richmond has an IP clinic. I'm not sure about University of Virginia and William and Mary. And then you can always look up registered patent attorneys and agents. So a note about that. Patent attorneys have a specialized license. So in addition to your bar license to practice law, you have to have a patent bar license to file and prosecute applications before the Patent and Trademark Office for patent for matters related to inventions and patents. You don't have to have it for the trademark side, but you do have to have it for the patent side. And so the USPTO has a list of all those who have met the requirements and received their registration to be patent attorneys and patent agents. So if you're ever wondering, you know, is this person registered to represent me in this patent matter before the PTO, you can look it up on their website. Virginia has a lawyer referral service where you can get a 30-minute consultation. They'll match you up with a lawyer for $35. And so it may be worth it to find out, you know, get some information, get referrals, or hire the attorney who you're consulting with for the matter. And then Washington Area Lawyers for the Arts has a lot of programs, educational programs and referrals for pro bono lawyers in the arts. And so those are resources that you can use. And again, I mentioned my images as we talked about copyright, of where I got them and how I use them. And so then I will end with questions. And as I stop sharing this, I do want to show you quickly, if we have a minute, I'd like to show you the patent and the trademark for Naturalicious and Gwen Jameer. Do I have that up? I believe I do. No. Okay. Show this real quick. Okay. So here is the patent. So she filed it in May of 2014. It was issued in August of 2015. And you'll see it says Williams. And you're like, I thought her name was Jameer, but remember she was going through a difficult divorce. So she probably changed back over to the J, which is Jameer, Gwendolyn Jameer. She's the applicant, inventor, and assignee. No legal representation, so she did it herself. And this is the patent. This is what it looks like. The US patent number is the number that you can reference on your product packaging to let people know that you own the patent. Remember, I mentioned the drawings and the claims. I'll show you in a minute, but you want to have information about the field of technology, the background on the invention, what the new and novel features are, being able to describe it, and then the claim. What is claimed? These three steps are important. These three claims are the claims of what she is saying is her invention. And anybody who uses something that has those claims, that's the meat and bulk of her rights right there. And so that's important to understand. And again, it's one of those things you can confer with a trademark attorney if you get search results and you see things. And this is her formula that she's got there. And she's comfortable disclosing it. It's not a trade secret because she has the patent protection if somebody infringes. And then this is her trademark, Naturalicious. So this is what a trademark registration looks like. It has the registration number. Again, you can use the R in the circle. And then again, it identifies products and services. So she has for Naturalicious, for hair care preparations, non-medicated skincare preparations, and for retail store services featuring beauty and cosmetics. So those are the goods and services that she trades under Naturalicious with. And so that's where I will leave it, and we will open it up to questions. Happy to indulge. Are there any questions?
Now you have an intellectual property protection attorney here who is willing to answer your questions. This is the perfect time for you to take advantage of this wonderful opportunity. I'm sure someone has a question for Attorney Black.
Well, I don't exactly have any questions necessarily because I thought things are pretty well explained, but my friend's band that he was in, they submitted their music onto this website, where you can purchase music, and some other group decided to take that exact same track and upload it onto the service and sell it. Needless to say, the waveforms were detected and they were able to track them down pretty fast. So I thought that'd be an interesting little tidbit to mention.
So they registered, is that the Creative Commons that they registered their
Yes.
works with? And then
Yep.
and in that they say what people can and can't do with their works, what rights they're willing to allow or license to people, right?
Yep. And that happens a lot with YouTube and stuff where, if you say, even if you're not doing it for profit, if you're just doing it for, to share music with other people, if you upload a certain track that say an artist doesn't want out there, obviously they can enact a copyright straight away to, remove the track. Or in other cases, they'll actually have it so that when it detects the copyright, they'll obtain whatever viewership monetization occurs for that property.
Yeah, you bring up a really good point, like when you mentioned YouTube and things. So a part of the Copyright Act includes the Digital Millennial Copyright Act and DMCA, which is a harbor for internet service providers, but they also have a responsibility to take down infringing material. So if you're a copyright owner and you upload that and you see somebody that's infringing and you notify them and you're able to establish your ownership, then they will take that down. And there's penalties for YouTubers who infringe on copyrights. And if you do it a certain number of times, they can then restrict your access and your privileges to that. And again, keep in mind, I mentioned, and this came up in a recent Supreme Court case, reiterating, because there were questions in case law about whether you had to have a registration for a copyright or whether an application was sufficient. But it reiterated the importance and the necessity of a registration certificate from the U.S. Copyright Office to then take action, legal action against infringers. So the cost of a copyright, a filing to get the registration, is less than $100. You can do it yourself. But it's worth a lot if you find that you're putting things out there and you're concerned about piracy and infringement of your materials.
Good afternoon, Attorney Black. I have 2 questions. Can you hear me?
Yes, I can.
Okay, good. Question number 1, I noticed Facebook's a lot of times people may post a video and they'll have a song that was made by somebody else playing in the background. And what they'll do is they'll put a disclaimer saying we own no rights to this particular song. Is that sufficient enough for protection against being sued?
So how I'm going to answer that is kind of sharing the law on a larger view, right? Because we're not going to give legal advice for anything. But what I will say is that what the copyright gives you is it gives you the right to make copies. It gives you the right to make derivative works, to distribute it, to publicly display it, to publicly perform it, right? So those are the rights of the copyright owner. And if any of those rights are infringed, then you may have a cause of action. Again, you need the registration. There is what's called, and some people enforce their rights and some people don't, but there also is what's called fair use exception. And that's used a lot in the education industry. And fair use gets into how much of the material was taken, how it affects the market share, the essence, was it the essence of what was taken and what the purpose of it was, how it's being used. Is it used for criticism or commentary or parody or, all those kind of things. And there's a really interesting case that involves Prince and Let's Go Crazy. And a woman had that song playing in the background with her toddler dancing around with his little his little mower in the kitchen. She posted it on social media, and through Prince, through I think it was Universal Studios owned it, not Universal Studios, but Sony. I can't remember which production company, but anyway, they said had it taken down. She's like, well, no, I think it should come back up. And they battled back and forth on the issue of whether she had fair use to use that snippet of his music. And in the end, what came about is that copyright owners have to really understand if what's being used is fair use or not. And also, an understanding of that kind of snippet and whether that was really enough to constitute infringement. And so, again, it gets into the facts and the nuances. Transformative use is a new thing of, I used it, but I used it in such a transformative way that it doesn't really infringe on the original work, So it really is fact driven, to answer your question, but I hope those examples give you a better understanding that it's not a clean cut yes or no answer.
Okay, thank you. My second question, you had mentioned earlier in your presentation about this discrimination law, I guess hair styles and all that. Now the question that I have is, how far does that law go as pertains to, let me back up. Where is the line drawn where that law is enforced? Say, for example, if you have somebody who wears dreadlocks and they're working at a restaurant and, you know, it's long and people don't want that exposed to food and all that. So I guess my question is, how far does that law go as it pertains to how well the hairstyle is kept well groomed?
So that's a good question, and the way that discrimination laws work, I mean, if you look at Title VII, and you can't discriminate against a person for race or color or sexual orientation now is covered under that, gender is covered under that, religion, you know, you're looking at the test of the rules and the policies of a company, right? And what kind of policies do they put in place, and whether those policies have any disparate impact or disparate treatment, meaning are those rules intentional that they then affect a certain protected class under the law, or are the rules neutral and they just adversely affect a protected class, and are there reasons for that? And so, you know, companies are still allowed to make rules, but they cannot intentionally violate rights of people, or they cannot intentionally discriminate. And so you have to look again at the facts, but if you're not even counting the Crown Act, in a lot of restaurants, they require nets and they require hats and they require coverings for the safety and the health and the safety of how food is transported or cooked or things like that. So you have to look at those rules and look at the and the law and see if that's violating rights that are protected, and there's not really a neutral basis or a legal basis for those rules.
Okay, well, thank you. So it sounds like what you're saying is that it really depends on how good your lawyer is. Well, thank you.
You're welcome. Okay, I see it. Can a person trademark both the image and the words? Yes. So a logo can be trademarked. Any of those individual things that I brought up, the word, the design, in combination by itself, like you saw McDonald's has the M and the word McDonald's. So you can do it in a combination. You can do it separately. Sometimes you'll have companies that just do the word, then they just do the logo, then they do the combination, and word marks, just the words, just the text of it, right? It's called standard character registrations are important because with Amazon now, a lot of times they require a trademark registration and they just want it as the word feature. You can stylize it any way you want to once the words are protected, but that's why there's certain strategies, business strategies that people will use to have multiple registrations of the mark, but you can do it in combination and you can do them individually. So it looks like there's a question about the presentation deck, Dr. Perry Rivers. I don't know that we talked about that, and I don't know if you want to address that.
So I'm going to look in chat. There's a question that you indicated that I should address. Is that what you?
Yeah, there's a question in the chat about sharing the presentation.
Oh, absolutely. So this wonderful presentation will be made available on our website at minoritysmallbusinesslaunchcenter.com. So I'm going to share my screen really quickly with you guys, just so that you can know where you'll be able to access this wonderful information. If you see my screen here, then you're able to see where we've got a list of all of our events, and then we have event videos. Under event videos, you'll actually be able to go and look at her introduction to her workshop that she provided us earlier. And then you'll actually also be able to go back and repetitively view this very thorough and detailed intellectual property protection workshop where you found out about the definitions of all the different types of intellectual property and how you'd be able to protect those assets. So you will be able to see this. It will probably be available by next week this time, but everyone that is in this session, if you have registered for the Minority Small Business Launch Center, then you will get an email that lets you know that this video is available. We also send it out to all of our partners. I also send it out to my students. So most of the people that are here will get an email that lets them know that it's available.
Okay. It looks like I think we have time for one more question. And before I answer that, because I know we're at the time part, I want to leave you with something. You know, I was thinking about like, what is it that I want you to know? And I really want you to know that intellectual property is a really important part of your business. And understanding that gives you the empowerment to generate economic wealth for yourself and generations to come. And so what I really want you to be able to get out of this is understanding that you can do it. I mean, I used the Gwen Jameer story to inspire you that even if you don't have a lawyer and even if you don't have a lot of money, you can do it. And then I provided you with the resources, especially with the Patent and Trademark Office and the legal representation, that you can get the resources to take the next step. Just as you're filing for your LLC or whatever next steps you're doing for the business, include the steps to protect your intellectual property. Those NDA agreements are critical to protect it before it gets out there. So I hope that you walk away with those things in mind from this workshop, and that the answers of what types of intellectual property that 75% of you said you had were answered through the workshop. Okay, so then I'll take this one last question. What are some examples of intellectual property that students on campus at VSU may be involved in creating or otherwise interacting that they may not be aware of and could potentially serve as a source of income? You are thinking critically. I love critical thinkers. And so most universities, and I'm assuming that VSU has one, actually, I'm pretty sure that they do, have intellectual property policies. And those policies lay out what type of work is considered the universities, what kind of work is considered collaborative with the university and maybe faculty or employees, and even things with students. And so you want to first understand what the policy is at your university. And in terms of working for the university and collaborative efforts with the university in creating things and inventing things, that is going to be your guidance on what type of rights you might have or potential income. If you create something outside of your role with the university that's just yours, then use the information that we've provided to try to figure out what you have, how to protect it, and how to enforce it. But as far as your intellectual property with the campus, that would really be the guidance that's provided with the university's policies and procedures that you should have access to.
Yes, and there are some written policies associated with innovations that are created utilizing equipment and resources that have been provided here. But I will say that for the most part, if you're doing most of the innovative work on your own time or outside of the university, then the university is usually very liberal and doesn't enforce very strongly getting a cut of your intellectual property rights. So, but I would like to just say thank you so much, Attorney Black, for this wonderful, 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 wonderful webinar on intellectual property protection. We are so, so, so fortunate that we have been able to host someone like you, and for you to be able to share all of this very valuable information to our student body, our faculty members. I see several of them here. We've got partners that are listening in, and we just are so appreciative. So let's everyone just give her a warm hand of thanks for her wonderful seminar.
It's been an honor. It's been an honor, and I'm glad to do that. And Dr. Perry Rivers, you mentioned that it'll be up, but are there other people that can register later to view it? And how do they go about that?
Well, everyone that is new to the Minority Small Business Launch Center can register for the Small Business Launch Center by going to our main website, which is, I know it's a long site, but Minority Small Business Launch Center.com with no spaces or hyphens. And then you go here, you click on enroll for free.
Okay.
And then technically, when you click on enroll for free, then you are entitled to free access to Attorney Black's intellectual property protection workshop. You're also entitled to our free certification training. You're also entitled to a free website, and then all of our other resources. So she is one of our partners.
And one of the reasons I'm doing this, and I'm so excited to hear that, is because these are the resources that we need. And, you know, I get questions all the time, and I'm going to be excited to be able to refer small businesses to this this website and this center. So I'm glad to be partnering with you, and I'm really excited, Dr. Perry Rivers, for what you have done. I think this is going to be a game changer for our community, and I really appreciate the investment that you've made, and I'm honored to be partnering with you on this. So
and we're grateful.
Congratulations to you too.
Thank you so much. And so this will conclude our wonderful intellectual property protection webinar. If you have any follow-up questions, then you can feel free to reach out to me by email pperry-rivers@vsu.edu, or to contact us by going to our site at the Minority Small Business Launch Center.com, and then you can click on contact us. So thank you everyone for coming, and everyone have a wonderful, wonderful, safe rest of your day.
Thank you. Bye.
Bye-bye, everyone.